May I commence by thanking CEDA, through you, Stephen, for the opportunity to speak to the Competition Policy Review. This is one of the first occasions on which I've had the opportunity to do so as Chair, and I welcome that and thank CEDA for providing that platform. Can I also acknowledge two of my three co-panellists, Sue McCluskey down here, Peter Anderson a bit further back in the auditorium, who are with us this afternoon. We're a panel of four, and it's my great privilege to chair the panel, and we're also ably assisted by a secretariat across in the Treasury, consisting of senior Treasury officers and some other officers from around the public sector, including some secondees from the ACCC and the Department of Prime Minister and Cabinet and elsewhere. So we're very ably assisted in the whole process, and certainly if it's to be the success that Rod has kindly indicated he hopes it will be, it'll be a lot to do with the support that we've received. So thank you for that. Well, as I mentioned a moment ago, we're well and truly underway now. The panel itself was announced on the 27th of March by the Honourable Bruce Bilson, Minister for Small Business, Competition Policy and Consumer Protection. I think it's important to remember the Minister's full title. Mr Bilson is a Cabinet Minister. The fact that his title is shortened sometimes leads people to think that this review is just about small business. That isn't the case. In fact, the Minister's title is very apt: Small Business, Competition Policy and Consumer Protection. There are the four of us there. The one I didn't mention was Michael O'Brien QC, who is a legal expert. Many of you may well be aware of Michael's work as a competition lawyer, and the three of us I've mentioned already. We issued a consultation paper fairly early in the piece, and that has now received a number of submissions. They closed formally on the 10th of June, but we've given extensions to the 27th of this month to various parties who requested it, including the ACCC. So if you look on the website, and I welcome you to do that, the website is competitionpolicyreview.gov.au. You'll find there all of the submissions that have been submitted to date, but I do make the point that that isn't the whole lot. There are about 160 of them there, and with various representations to us, we're led to believe that we may crack 300 submissions in toto. And at this stage, submissions from major bodies like the ACCC, the BCA, various state governments are yet to appear. So watch this space, as they say. Well, Rod's given really a very clear and well-directed overview of the work that the review has been asked to do. So forgive me if I briefly go over the same territory. I don't think the repetition will be a problem, because it's important that we do have a clear sense of what it is that this inquiry has been asked to do and what it's not been asked to do. It is about competition policy, and competition drives choice, efficiency and innovation. And you'll hear more of that as this review proceeds. That is the lens through which we're viewing many of the things that have been brought to us. How do these changes, the notions, the ideas that people put before us, how do they enhance the competitive process? Which means, how do they engender, re-energise, support choice, efficiency and innovation? These things are important, of course, because they underpin productivity. They're not the only thing that drives productivity. But when it comes to growing Australia's productivity, competition policy is one of the key instruments that's available to us to do exactly that. We often hear about the importance of productivity growth, particularly as the mining investment boom wanes and is replaced by the output or export phase of the mining boom. But as the peak of the mining boom passes, and as the Australian economy faces other major structural changes driven by demographics, technology, globalisation, we're reminded how important it is that we continue to grow our productivity. After all, that's what will sustain the growth in Australian living standards over time. Well, all of that seems to me to be unexceptionable, and what this review panel has been asked to do is to think about how competition policy, one of the key instruments which drives productivity growth and hence the growth in living standards, how's that travelling? Competition policy, if you like, you can date it way back to the Whitlam era with the initiation of the Trade Practices Act, and more recently, of course, with the Hilmer process and the creation of the ACCC and what is now called the Competition and Consumer Act. So competition policy itself is not new, nor are the instruments of competition policy, the law and the regulators. but it's appropriate that they be reviewed, simply partly because of the passage of time. It's a helpful thing to review institutions and policies from time to time, and 20 years seems like a reasonable time to do that. There's also been, as you've heard Rod already indicate a moment ago, a concern that the momentum created by the national competition policy through the original Hilmer review has flagged somewhat. There have obviously been major changes in the structure of the Australian economy since Fred Hilmer's work in the early 1990s and in prospect as we go forward. So change is ever with us, and the sorts of changes that we're experiencing have a bearing on how competition policy works. So there's the logic. Given the importance of competition policy, how germane it is to Australia's productivity challenge, are the existing instruments and institutions up to the task that we face now, and perhaps even more so over the next 20 years? Take a look, see how it's travelling, see what people think, and bring to the government some recommended changes. That's our task. And as I mentioned, maybe the forward-looking part of this agenda is perhaps the most important. Certainly that is a view that the Minister has shared with us. The government is particularly keen that whatever we come up with and make recommendation to them be tuned for the forward view of how the Australian economy is changing. If you've read some of the submissions, you will see that that theme gets picked up in submissions as well. But whatever you might think about institutions and policies now, really the test is how they'll travel over the next 20 years or so. Now, the reality is that they've travelled pretty well over the past 20 years, and I think that we can stand back and say, you know, our institutions and policies in this area have been pretty robust, and the Productivity Commission has taken a view from time to time and done some estimates, which you'll find on the public record, pointing out how valuable this whole experience has been in terms of our living standards. We want to make sure that that momentum continues, particularly as the pace of change increases, new markets emerge, new technologies emerge, things that weren't even dreamt of, I think, at the time that the Hilmer Committee was sitting. After all, Hilmer reported in 1993, and the World Wide Web wasn't switched on until 1996. So the whole prospect of digital disruption, what that has done to the definitions of markets and how the competitive process works, is something which has changed dramatically over the last 2 decades. That, in and of itself, would be a good reason to think again about these issues. Well, what is it proposed that we cover? I have really the same list as Rod has just given you, but the order is slightly different, so therefore you can see I didn't get it from him. He may have gotten it from me, but there you are. First up, the unfinished business from Hilmer. The Hilmer process went a long way, but part of the reason that people like Rod and others indicate the view that maybe this momentum is flagging is that you can see areas in which even what Hilmer said should be done back in the 1990s really remains undone. In different areas, different parts of the economy, in different states, there are things which Hilmer recommended be done that have not been done. Well, let's have a look at that. Where are the priorities there? What have we learned about what creates momentum and what leads momentum to flag? How might that process be re-energised? What would be the key that would do that? And where could it go further? You've heard me say a moment ago that the structure of the Australian economy has changed a good deal since Fred and his colleagues were inquiring into the competition process back then, and it's slated to change even more over the next 20 years. Just to take 2 examples, in health and education, for example, these were not areas that Hilmer recommended the competitive process should be drawn into, and yet all the forecasts, including forecasts from my colleagues at Deloitte Access Economics, show that the health sector in particular will become an increasingly large and important sector within the Australian economy as our demographics take over and as people's demands for health services grow, just as we get richer. So what role can the competitive process play in a sector like health, which has been traditionally dominated by public provision, let alone public funding? Education, similar story. Intellectual property, another area just left off the Hilmer agenda, but something which clearly is going to play a much more important role going forward and already does compared to 20 years ago. What sorts of proposals might we come up with that could extend the competitive process, tune it for those parts of the Australian economy? So there's Hilmer, if you like, Part A, unfinished business, Part B, new horizons for a Hilmer-style competition process. Secondly, the institutions and governance arrangements that can drive reform. Ladies and gentlemen, it's not the task of the four of these panellists chosen by the government to conduct this review to arbitrate each and every one of the issues that are brought before us. That would be an impossible task given the breadth of the terms of reference, but also one highly inappropriate for four people who are simply asked to review. We're not a court of law. We're not hearing evidence according to the same standards that a court would hear evidence. We view our task as making recommendations to the government about the appropriate institutions and their governance arrangements, which will take whatever policies and approaches we recommend to the government, take those, and if the government agrees and assigns them to these institutions and their governance arrangements, carry this forward. After all, the ACCC is a creature of Hilmer. So institutions are the leading edge of policy. It's one thing to come up with a decent idea. It's another thing to build into the system institutions which are robust, which operate under an appropriate governance framework, which have incentives and momentum which can deliver on the policy objectives the government has chosen. This is something which my colleagues and I are extremely focused on, the question of good institutional design. Economic policy is one thing, but it's institutional conduct, how you build it into the institutional framework for delivery over time, is an extremely important and tricky question. One of the things that my panellists and I decided to do early in the piece was not to traipse off overseas ourselves and engage in a rather, the tiring process of visiting one foreign government after another, but instead to bring experts here to Australia to address specific questions, drawing on their international expertise, giving us a perspective of what things look like from outside Australia. And importantly, having what they have to say able to be heard by you as well as just us. So we are setting up an international conference at the end of October. It will be about 3 or 4 weeks after we release our draft report, so that'll be out there as grist to the mill as well. And we'll have a public conference to which we've invited 3 international experts, essentially whose expertise is lined up with these 3 points I'm giving to you at the moment. An expert on the reform process, an expert on institutional design, and then an expert on competition law. And at that conference, as I say, we hope to hear from those people as well as local experts in the context of what we've said in our draft report, but also more generally. So the expertise and insight which those international experts can bring to us in thinking about these issues can be shared beyond just the panellists. That's our intention. Okay, so Hilmer A and B, the institutions and the governance arrangements, and then finally, of course, the competition law itself. Is it working as it was intended to work? So there's competition policy, the aim to try to drive the competitive process. It undergirds choice, efficiency, innovation. It is delivered by the law and institutions that are built on the law. How's all that package travelling? And how well is it structured for what lies ahead? I mentioned that we've had submissions. We've still got quite a few to come. Those submissions have been drawn from right across the spectrum. Individuals, sole traders, small and large business, professional lobby groups and governments yet to come. So there's a wide range of views, and if you're at all interested in these issues, as you should be, then can I recommend that you take a bit of a look through those submissions from time to time to get a sense of the sorts of issues that people are raising. What I'll do in the next few minutes is just to give you a brief overview of how they've come in at this stage, sorts of things that people are raising with us. People do point to the fact that a number of the issues that are before us in our terms of reference are the subject of other reviews, either contemporaneous with us, like the Murray Review, looking at different aspects of competition in the financial system. Beyond that, there are other reviews operating presently into water and infrastructure, being run by different groups. Indeed, we're aware of that, and we're also aware of, we're in touch with other inquiries to make sure that we don't duplicate the effort, but that we do take advantage of work that's already being done in these related areas. Inquiries have already taken place into taxis, pharmacies, supermarkets. We're aware that these are issues that have been well examined in some cases. It doesn't matter. We can benefit from what others have said and take a fresh perspective. There are also issues that we've not heard much about. Planning and zoning rules from local government get quite a run in these submissions, and thinking about how the process of competitive neutrality can apply at the level of local government. Hilmer mostly applied this at the level of the state government and the Commonwealth. In this case, most of the issues that have been raised in submissions to do with competitive neutrality affect the local sector more so than either the state or the Commonwealth. And there's a series of issues which you would expect that surround the operation of the competition law. Comments about the national access regime, comments about secondary boycott provisions in the Competition and Consumer Act, views about Section 50 and the merger law, as well as the process that the ACCC and the Tribunal undertake in determining the outcomes of merger requests. The misuse of market power, which Rod has already indicated. Other people as well have views about the effects tests and various other changes that might be made to better target anti-competitive conduct. And there are exceptions in the competition law as well. People have views about things like intellectual property, as I've mentioned to you, the terms and conditions of employment. In other words, how does the Consumer and Competition Act articulate with the Fair Work Act? People have views about that, as well as liner shipping in Part 10 and so forth. Quite a lot to do with the law itself. The ACCC, Rod would be unsurprised to hear, is the subject of quite a lot of comment. There are others who think that the toolkit for the ACCC should be augmented, and this notion that the chairman has just raised about possibly adding market studies or market investigations to the toolkit for the ACCC. There are others like Choice who think the same way. And there's a general theme of dissatisfaction with mergers. Rod would be unsurprised to hear that. The desire for more information, the fact that it takes a long time, the fact that perhaps the ACCC's modus operandi is not commercial or not well tuned to commercial reality. Questions about access to justice have been raised significantly by small business. There are quite a few small business representatives, not all of them, but quite a few who will say, actually, there's nothing wrong with the law. The way the law is written is fine. I emphasise that not every small business has that view. There are others who want to add to the law. But there are many who say, yeah, it's fine. Well, then why don't you use the law? Well, we can't get the regulator to act. Why not? Well, the regulator tells us we haven't got a case. Well, maybe the regulator's right. Why don't you test it? Well, we couldn't possibly do that. We can't afford it. And if we go to court, we'll be done over by those whom we're taking the action against in the commercial sphere. It's simply unrealistic. So you're trying to tell us then that you can't get access to justice. Some of them will say that's exactly what we mean. We want the ACCC to run test cases. We want to have a sense that we can get at the law. What use is the law to us if we can't get access to justice? Well, there are arguments that you can hear made, and of course it's up to my colleagues and I to determine how we think about those arguments, but it's interesting to see them in that form. I've mentioned about extending competition reform. There are views from people who've come forward and said, well, you should go very cautiously in thinking about how competition could be extended into health and education, because classically these are areas, particularly health, where the capacity for consumers to choose is attenuated by information problems at the very least. So go cautiously. There are views about that. And finally, I mentioned local government again. Competitive neutrality issues, concerns particularly about local government either directly entering into businesses. Waste management is one issue that's been raised. Someone else told us about a local government that decided it wanted to run a picture theatre in a small town as part of its tourism outreach. Seems sensible enough unless you happen to be the owner of the only other picture theatre in town. And then you discover that the local government's picture theatre has been given its projection-free, its projection equipment and its premises and all the rest. You think, well, okay. The question is, how are these things handled? Is this something that the state government is responsible for in the end, or is there some mechanism that we should be thinking about which enjoins local governments to think about competitive neutrality as seriously as many of the state governments have already done post-Hilmer? Well, there it is as we presently stand. It's a broad-ranging review. People have said these terms of reference are very broad, and they are. If you're thinking about that, can I remind you about those three areas that we've chunked it down into? Unfinished business from Hilmer plus extending Hilmer, the institutions and their governance, and the competition law. Those are the three key areas that my colleagues and I have narrowed the terms of reference down to. And I'd invite you to think about our terms of reference through that lens. We'll be working through the issues that have been raised. We won't be adjudicating all of them. Naturally, there are ones we'll express a view on, but I wouldn't hesitate. In fact, I'll be very clear to this audience that it isn't our role, as we see it, to adjudicate each of these claims. It is to bring forward to the government some recommendations about the processes by which these matters may well be determined, if they can't be determined prima facie by a group like ourselves. We'll look at institutional frameworks and principles. We have a draft report which is due in September. Then there'll be our conference I mentioned to you in October, and we're required to report to the government through Minister Bilson no later than March next year. Thank you very much.